There it is. Welcome. It's a state recovery presentation on Medicaid estate recovery. I've passed out 3 documents to each of you. One, you have the brochure. This is the common brochure that we pass out for all to Department of Human Services units and other places. General brochure. You've also got a 10-question questionnaire or questions that kind of summarize the presentation today. I'm going to use it kind of like an agenda for today's meeting. I spoke a few days ago in Iowa City and I used something like this, and it was probably the best meeting we've ever had because it was very interactive. We had a lot of questions and answers, and that's the way I like to handle these presentations. Is several of you have probably been to these before. You've heard me speak, and it's the same general topics, but there's probably 4 hours of material or more that I could go over. So to put it into 1 hour, I have to skip some of the things that some of you might be interested in. So I always say if there's questions that you want to ask, please ask them and we'll cover those. And I usually get to them in a certain order, which is in the topics that are set forth on this these estate recovery topic questions sheet. And finally, you've got the outline. And again, this is something I present every time I speak to, especially to a group of attorneys. I did add some things. Actually, I was working on it this morning to update it. So it's current as of today. There's one on our website that's very similar. The website is noted at the bottom of the front page. It has one from 2012. It's not incorrect, but it's not updated either. There's a couple things I added this morning, including there's a paragraph about the Affordable Care Act and how that works with estate recovery. And there's also a reference this year to the Melby case, which came out this year in 2014. So this is the most current version of this outline for this group. I'm going to go ahead and start into the first question: who is subject to estate recovery? And this is always important for attorneys because they want to know, is this even a problem they have to deal with? Who is subject to estate recovery? Typically, it has to be a Medicaid recipient, not Medicare, and some people do get confused, but it's Medicaid. They have to be 55 years of age or older, or in long-term care. And I've abbreviated that a little bit in my estate recovery topic questions. If you go to the outline, you can see a very similar description of those same questions in basically the table of contents for the outline. So that's what who is subject to estate recovery is those over 55 on Medicaid or those in long-term care. The reason it's stated that way is some states only collect long-term care, and which had an effect then when the Affordable Care Act passed, which I'll get to in a few minutes. And other states collect not only long-term care, but people 55 and over. And it's split about, I think it's 20 states one way and 30 states the other, or the District of Columbia. It's one of the 2 options in the federal statute that states have when they choose or when they implement their estate recovery programs. One is, who do you collect from? Is it just long-term care, or is it long-term care and 55 and over, 55 and over being the option? The other big option is, are you going to collect from just what's in probate, or are you going to go with the expanded probate definition? And Iowa has chosen the expanded probate definition. So in both of those options in the federal statute, Iowa has elected to collect as much as can be, as well as many other states, including Minnesota, Wisconsin, etc. One option that it's not really in the estate recovery part of the statute, but just before it is what's called TEFRA liens. TEFRA being Tax Equity Financial and Responsibility Act, I believe, of the early 1990s, and that allows the state to put liens on property to secure the debts before death. Iowa did not elect to do that. We do not put real estate liens on property while the Medicaid recipients are living. Many states do that, and it often gets confused in Iowa because neighboring states do it quite a bit. Minnesota, Wisconsin, Illinois all have liens, and we do not have those in Iowa.
Ben,
Yeah.
that over 55 thing,
Yes, that's correct. And I probably should repeat the question, that if an SSI person received benefits, Medicaid benefits, up until the age of 55, say they're 35 or 40, is there Medicaid estate recovery? No, there's not. It's very specifically defined, only people in long-term care or those 55 years of age or older. And the people in long-term care are presumed not to return home. So if somebody's in the nursing home for a broken leg and then they die for unrelated causes, and they weren't expected to stay in the nursing home, there would not be a state recovery. Now, most people go in the nursing home and they're under 55, they're not in very good shape, and they probably weren't expected to get out anyway, but there is also that consideration for people under 55. It's not a big source of recovery. Often the people under 55 are disabled in some manner and have not accumulated a lot of assets, but there are some, and there are some recoveries from that age group also. I'm going to go on to what establishes the debt, and that would be, and I've got it very briefly described as fee-for-service and capitation payments. The fee-for-service would be just the regular, go to the doctor, get a medical bill paid, or Medicaid pays for it. That is recorded on what's called the Medicaid Management Information System, and a report is provided to us saying this is the assistance provided to the Medicaid recipient. We obtain those after death. There are also what's called capitation payments, and some of those show up on the history reports. Some of them do not. The best example, I think, is the Medicare premiums that are paid by Medicaid. They call it the Medicare buy-in because Medicaid buys into the Medicare program. Those show up on a separate report, and to the extent Medicaid pays for those, they're subject to recovery. There's a third type of capitation payment. Well, there's a couple more types, but the third major type that's been hitting the news, especially the first part of this year, was the Affordable Care Act. Affordable Care Act shows up as another type of capitation payment. It's a monthly payment from the Medicaid program to either a private insurance company for people 100% of poverty to 133% of poverty, or to a HMO or health management organization for people 100% of poverty level or below. But either way, the amount Medicaid pays out should be a monthly premium to the basically insurance company or insurance type of company. There is a gap sometimes when somebody signs up that they don't get enrolled with the insurance company right away, so there might be some out-of-pocket fee-for-service charges also before they actually get into that insurance or HMO. So when people have called and said, you know, what is this Affordable Care Act? Why am I being forced to sign up for it? And then Medicaid will collect through a state recovery. Do you have a question? So they call and ask why they're subject to a state recovery. It's because Medicaid is paying, and if they're over 55, then it is subject to recovery, just as anybody else who is subject to a Medicaid program. Medicaid pays out, and it's usually just the insurance premiums, then it has to be paid back. And often what we'll do, if they're not sure if they had some preliminary or they're not sure of the amount of the monthly payment, we'll just have them call member services at the Medicaid office and ask them how much has been paid on my behalf, and they can kind of see what's being paid monthly through the Affordable Care Act plan. There is some confusion also with the Affordable Care Act in that if you're under 133%, you get your full premium paid by Medicaid, and it's subject to recovery. But if you're earning just over that, then you're under the Federal Exchange Subsidy Program. And when you're in that program, you might pay $100 or $120 for your premium, and the federal government will subsidize the rest of it. Well, people who are under 133% say, how come I have to pay $500 when I die when the subsidized people are paying $120 and they don't have to pay anything more? And the answer is that Medicaid pays for those people 133% or under. That's the program. That's the way it works. There's a state recovery for 55 and over. The other program is by the federal government, and what they do is what they do. And it's just the way it works is they've got a federally subsidized program, they at least have to buy into some of it initially, as opposed to the Medicaid people who aren't paying anything up front. Also, although they believe that they will pay at the time of death, about 65 to 70% of the estate recovery Medicaid people, there is no recovery. I mean, because they're in such a low income, they just don't have any money at the time of death anyway. So for all practical purposes, about two-thirds of the Medicaid recipients now, and possibly the affordable care people later, may not have any recovery in the future anyway. Another difference with that group is that all other Medicaid, there's an asset limit or asset review before obtaining Medicaid. But for Affordable Care Act, there is no asset review. So people can have a lot of assets. I know we talked to someone who had several rental houses, like 10 or 12 rental houses, but her income was very low. I don't know if the rent wasn't working out or what, but she qualified, but she had a lot of assets. So.
When you say she qualified under the
Affordable Care Act, yes.
So there'd be this premium payment, capitation fee payment, that would be subject to recovery.
Correct. Yeah. Yes. And so whatever Medicaid pays out has to be collected for people over 55. It's also a little conflict with the Affordable Care Act in that the Affordable Care Act covers people from age 21 to age 65, up to age 65, which is the working age population is what they call it. Well, estate recovery starts at 55 and forward. So a lot of people see this as estate recovery for Affordable Care Act from age 55 when estate recovery starts until 65 when they drop off. And why is that group, age 55 to 65, have estate recovery when people older and younger don't? Which is one way to look at it. And I look at it that, yes, they're on the Affordable Care Act subject to recovery from 55 to 65, but just as any other Medicaid program, it's subject to recovery from 55 and forward. So at age 65, if they still need medical care and they still need Medicaid, there's still going to be recovery. On the other hand, if they drop off the Affordable Care Act at age 59, it's going to be age 55 to 59. So it's just Medicaid forward for whatever Medicaid programs you're on, and the Affordable Care Act is just one of them. And just because it drops off and they might get onto some other Medicaid program or they might not, estate recovery is just going to collect from age 55 and forward. So, we're under what establishes the debt. There is one exception for medical expenses that are not subject to recovery, and that was passed in 2008, effective January 1st of 2010, and that is what is called the Medicare Cost Sharing Program. And it's in the outline exactly what programs it is, but it's generally the QMB, SLMB, and things related to those, QMB and SLMB persons, the Medicare Cost Sharing Program. When people are on that type of program, when we request the amount of the debt, that amount is just excluded from the reports that we get. So if Greg or Tom have a client who's on Medicaid in the Medicare Cost Sharing Program, which is over 65, and they notify us that the person was on Medicaid, we may report back, we don't have a claim for this person. And they could say, we know the person was on Medicaid. Well, they might have been, but there's no claim for the person if they were under those programs, and only under those programs. And I've heard people switch on and off those programs a bit, so they might have a claim for part of the time, not for the rest of the time, because they've gone on and off the Medicare Cost Sharing Program. So generally that answers the second question of what establishes the debt. If anybody has any questions about who is subject to estate recovery or what establishes the debt, let me know. Otherwise we'll go on to when does a waiver apply. There are, I like to think of it as two different types of waivers for estate recovery. And waivers for estate recovery do not waive the debt completely. They only waive the debt until the person who received the waiver passes away, or in the cases of an undue hardship waiver, when the person either passes away or no longer qualifies for the hardship waiver. So the two types of waivers are either what I call categorical waivers or hardship waivers. The categorical waivers are, if you are this type of person, you automatically get the waiver. There's the spouse, automatic waiver. It doesn't matter what her assets are. If she's the spouse or he's the spouse, there's a waiver for the recipient's debt until the time of the spouse's death. Same thing with the disabled child. And same thing with the minor child. The debt's automatically waived. The difference with the minor child is the debt comes back when the person turns 21 years of age. And I don't know exactly why estate recovery starts at age 55, but from working with the program for 15, 16 years or so, it does eliminate a lot of minor child problems or waivers starting at age 55. We have very few, usually less than 5 or 10 at any one time, where that person is then that minor child category of the debt being waived. And usually the waivers, we've had a couple of houses given to minor children, but usually it's a few $100 or $1,000 in a bank account. It's usually not a major issue. Those are the categorical waivers. Let me give an example. I like to give an example of the spouse issue, which is nearly identical to a disabled child. The spouse waiver, if the spouse on Medicaid is able to transfer all their assets to the surviving spouse before the person goes on Medicaid through the proper eligibility review and transfers that they can do, then there is no recovery when the surviving spouse dies, because the Medicaid recipient had no assets at the time of the Medicaid recipient's passing. If, on the other hand, the house continues to be held jointly between the two, say a $100,000 house is $50,000 owned by each, then at the time of death, there will be $50,000 due at the time of from the recipient, and then that amount, $50,000, will be deferred until the surviving spouse's death, assuming the Medicaid debt is, of course, larger than $50,000. If it's less than the $50,000, then whatever the Medicaid debt is will be due from the surviving spouse's estate.
Then, as you talked about successive deaths and the waivers, the code language, I tend to think of it as a deferral when you have a spouse. What do you do about tracing assets? So the house is a good example. The healthier spouse or the survivor receives the house, they sell a year or two later, now they have cash that they presumably use for living expenses. They may have other assets too. So how do you track that, or do you?
Okay. The question is whether or how the assets are tracked from the time of the Medicaid recipient's spouse's death, Medicaid recipient's death, until the surviving spouse's death. The issue often raised also is, can the spouse even spend those assets? And the answer, of course, is yes. That is the reason for the spouse waiver, is because a big policy initiative when Medicaid was passed was to protect the impoverished spouses. They didn't want spouses to be spending for a sick other spouse and not have any money when that spouse died. So if you could put one spouse on Medicaid, and the surviving spouse would have enough to live on. So they are free to sell their house. They're free to spend the money down. If they have nothing at the time of the surviving spouse's death, then there is no recovery. If, on the other hand, the house is still there, it will be subject to recovery. And the way we trace those assets, so to speak, is a little misleading using the word trace. We don't follow people while they're living. What we'll do is we have data matches that we find out when the surviving spouse dies, and we pull the records from the first spouse and see what assets were there. And we don't have to trace like a house or a car or anything else. We've had some people who spend down everything they receive from the Medicaid recipient spouse, and then they get more assets, and they say, well, the first spouse's assets are gone, now these are mine. And that is not the way it works. According to the statute, the collection is to the extent assets pass from one spouse to the other. So if it's $10,000, if it's $5,000, if it's $500 or whatever amount, that amount then it's gone and deferred, which is a good word also, for the lifetime of the surviving spouse, and then it comes down, that amount of the debt comes due against the surviving spouse's estate. And at that time, we'll pull the records and we'll see what passed. Like a house, we'll look at the real estate records online or any other records that we have, or most often we'll, like we do with a regular Medicaid recipient's death, we'll send a letter to the family and we'll explain the situation, explain how estate recovery works, and we'll ask for a report of the assets as far as what was left, because there's a legal obligation to pay back to the extent the surviving spouse had assets at the time of death. Oftentimes, and we found this early on, it's not the first spouse that has the Medicaid debt that's collected. Just in general terms, a lot of times there'll be a couple and they live together and they take care of each other. But then when one of them dies and the kids start looking at the situation and one's not taking care of the other, then the person goes to the nursing home. And at that point, Medicaid starts for the second spouse, and the house is still there. They say they intend to return home, and of course they don't, and the kids don't want to clean up and sell the house either, so when the surviving spouse dies, there's still a house there. The statistics were 60 to 70% of estate recoveries are from the homestead, and that's, I think, a fairly general situation of the way that happens with spouses.
Ben,
Yes?
about the surviving spouse spending on the assets. What if they decide to give the assets away?
Yeah, and they can do that. A spouse can do that. They can go to a casino, they can give it to their kids, they can go around the world a few times. It's a spouse's money. They can do with it what they want. The catch is that if they do those kinds of things and then they need Medicaid, they've got to wait another 5 years. And you know, we have had a surviving spouse come to our office with her family, her children say, "Can Mom give the house to me, or can Mom give assets to me?" And Mom's looking at him like, you know, "I was trying to save this money to take care of myself, and now my kids want to take the money." So sometimes, and this jives in well with the elder law section, you're trying to take care of the elder law person, not transfer assets to the kids. And if they're willing to take care of her for the rest of her life, you know, then that might be a situation. But if she's going to go on Medicaid, then they have to keep that in mind also.
Ben, the question I've had is on the, when you talked about when the first spouse dies who had received Medicaid, had no assets, then the second spouse dies, and the state recovery files a claim.
Mm-hmm.
And the response I've had in the past anyway was the state automatically grants that waiver. How do I, if the Medicaid recipient dies as $10, how do I get that $10 to you though, so then that claim's off the books, if you will, if we're not going to do appropriate?
When the first spouse dies?
When the first spouse dies, who was the Medicaid recipient?
Yeah. The way the statute is written, and the question again is between the first spouse and the second spouse and the assets, if the Medicaid recipient has assets that pass to the surviving spouse, the law says we cannot collect it to the extent it reduces an amount going to the surviving spouse. So if there's $10 or $100 or $1,000 that's passing from one to the other, the law says we cannot collect it. And we routinely return checks to surviving spouses when they've sent us a check because we cannot collect it. So they have to, they're instructed to use the money for their own care or for their own benefit or whatever the spouse wants to do up until the time the surviving spouse dies. And when the surviving spouse dies, if there's a probate estate opened, we'll file a claim for the entire amount, $100,000 or whatever, for the first spouse, but the second paragraph of that claim form says it's only due to the extent that assets pass from one spouse to the other. So it would only be the $10 or the $50 or whatever passed from one spouse to the other that's collectible from the second spouse's estate. Okay? Going on to undue hardship waivers, that is the other type of waiver, and it is not for a specific person. It can be for a nephew, it can be for a friend, it could be a live-in companion. Most often it's for children. And they're looked at on a case-by-case basis. There's only about 30 or 40 a year, which doesn't seem like a lot compared to the 10,000 cases we have going through our office every year. The requirements are that the person has less than $10,000 in assets, less than twice the poverty level in income, and collection of the debt will deprive the person of food, shelter, clothing, or medical care such that life or health would be endangered. And again, we routinely get those requests. Routinely they're approved, and very rarely denied because the definitions are so specific. You either meet them or you don't. And when those waivers are approved, it's typically for, nearly always, for a son or daughter who moved into the house toward the end of the elder parent's lifetime to take care of that person. And if the estate recovery recovers or the probate estate sells the house, they won't have a place to live. So for that situation especially, and for anyone else who qualifies, there is a hardship waiver that is effective until that person's death or until that person no longer qualifies. For example, if the house is sold, the house is $100,000, they sell it, then they're over the $10,000 limit, and the debt will have to be paid back to the extent of the debt, or we generally leave them the $10,000 to qualify, but the rest of it will have to be used, or enough assets to get up to the $10,000, but the rest of it will then be used to repay the Medicaid debt. Any other questions we have on waivers? Any waiver issues? I'll get on to assets. That's really where I try to spend a lot of time with attorneys, because attorneys are usually very interested in the assets and how estate recovery works with assets. There's generally two types of assets. According to the federal statute, as I mentioned earlier, there's the probate assets that every state can recover from, and then there's the expanded probate assets, which Iowa and about half the states have elected to recover from expanded probate assets. The typical probate assets would be the house and a bank account, any extra funds in funeral, in the burial trust, household goods, personal effects, like if there's a lawsuit, other types of litigation, that is typically a probate asset. With, even though there's no probate estate opened, there is collection of those assets. The best example is probably a bank account. There's bank accounts that are held solely by the deceased person. With those cases, often the son or daughter can file a small estate affidavit at least 40 days after death, or if they do not access those funds to pay funeral expenses or to help wind up the affairs to pay the Medicaid claim, our office can file a small estate affidavit at least 90 days after death. And then we can access those funds to pay back the Medicaid debt. Another type of ownership of a bank account might be jointly held. And jointly held gets a little confusing because it's one of those expanded probate assets, but with a bank account, no probate is open. The bank will tell the children or whoever is the joint holder of the account that it's that person's money, which it is according to their agreement with the bank. But if they had an interest in it, if the deceased person had an interest in it, and it's generally the Social Security funds going into the bank account, then those funds are subject to recovery to the extent that the deceased person had an interest in those accounts. They're often the family member will just include those on the form that we send out to them. The third type might be a pay-on-death account or some other type of joint account with the account holder. But regardless, if the decedent had an interest in it, then it will be subject to recovery. I should probably go into a little bit of the procedure of estate recovery because I mentioned this letter that goes out. And that's, people have asked, well, how do you find out about a deceased Medicaid recipient? Because sometimes they're not on Medicaid when they pass away. There are several different ways. First of all, family members call us. They've got information about estate recovery and they'll just call our office. Attorneys will call us or send us a letter or get online and do a referral. Also, nursing homes frequently have resident trust accounts, and they need to do something with those funds in the resident trust account, so they'll send us a referral. Or they will be owed money. And when they're owed money, of course, they want to let us know that they're owed money so they'll get paid ahead of our claim, especially if they have a medical bill of last illness. Funeral homes are required to send us notice if they have an excess burial fund. If they have a burial fund, there's excess money in it, they have to send us notice. Even if they don't know if there's Medicaid or not, they have to send us notice, and then we will let them know if there's actually a Medicaid debt. We'll send a letter requesting those funds when probate is not open. So funeral homes send us notices. Of course, attorneys send us probate notices. They're required to do that electronically now under the law, so we get referrals in that manner. And then, if none of those manual type of referrals result in opening a case, we also have several types of automated referrals. We have a monthly list that comes from the Department of Human Services. When someone passes away, they accumulate on a list. We have the DHS, when someone dies, they press a code on their computer, and that pops up a screen that makes them fill out a form about the deceased Medicaid person, and that comes to us weekly. The other one comes monthly. And then we have a data match with the vital statistic records in the state of Iowa. So in case the person went off Medicaid before death, then we'll get a report matching the Social Security number of the Medicaid recipient with the Social Security number of the people who died in Iowa. So that seems cumulative of most everyone, but we also have a national vital statistics list from the Social Security Administration that matches Social Security numbers to the Medicaid database, Iowa Medicaid database. For example, people might die up in Mayo Clinic or in another state, or they might have moved to Florida before they passed away, and there will often be claims on those cases also. So that's how we find out about deceased Medicaid recipients. And then it really breaks down into two different areas, and we have about 12 people in our office just doing estate recovery and what's called the Medicaid Trust Program. And about 3 or 4 of them work in the probate area, and the others work in the what we call non-probate area. So if we get a probate claim in, or if we send out a letter and find out a probate estate has been opened, those files will go over to the probate area, we'll file a claim, and we'll monitor those in probate. If there is no probate opened, then we will send letters and a form. The initial letter is informational. Maybe all of you have seen it. It's not only a one page with a lot of words on it, but a front and back information sheet on estate recovery and a questionnaire on the back. And that questionnaire will ask the person responsible for winding up the affairs the assets of the deceased person and the expenses of the deceased person. And often it will be a small bank account, not enough to pay the funeral expenses, and there won't be any recovery. Sometimes there will be assets reported, such as the house or other assets. If we don't get a report back, of course, we'll follow up with other letters. We'll check the public records and see if there are other assets and pursue the case as we deem necessary in those cases. The probates we follow up about every 5 or 6 months, I think, just give the attorney more time to sell the assets and do what they have to do. If there is a house and no probate estate is opened by the family after 6 months or a year, or when we understand that they will not be probating the estate, we will go ahead and open the probate administration also. That would also include, like for annuities or savings bonds, anything where the family will not be opening the estate, we can proceed to open the probate estate and liquidate the assets and pay the Medicaid claim. Household goods is a good question. Vehicles, household goods, those types of things. I always compare it to if the case is in probate and there's household goods and the attorney or executor determine there's an asset, then there's also an asset that should be reported for estate recovery. More often, I think it's the case where if you brought an auctioneer to look at the stuff, he'd walk out and say, "Are you kidding me? There's nothing here to sell that will pay my fee." Or if the person has in the nursing home, the TV and the chair, and you sit at a garage sale all day and it takes you all day to sell $50 worth, it's not worth paying the person sitting there just the minimum wage even to sell those things. So it's a determination made by the person winding up the affairs of the estate whether the household goods have a value to liquidate, just as if estate recovery wasn't involved. If there's 5 kids, is it worth it to sell the property and divide it amongst the kids, or parcel it out in equal value. It's a determination that's made by the personal representative. If we find out, and we have received auction notices saying personal property for sale, and then of course we'll know that there was assets that should be recovered and paid to the Medicaid debt after the auctioneer has been paid. So that's on household goods. Vehicles are similar, and to the extent that there isn't often a lot of vehicles and there's not often a lot of household goods that are recovered through estate recovery. But we will request that they get a blue book value off the internet, see what the value is, sell the vehicle, and pay back any money after other expenses. As part of doing the work of selling the vehicle or winding up the affairs of the estate, we allow a 3% fee, just like the small estate chapter. If somebody wants to take a 3% fee and report that on the response form, we're very willing to allow that payment to the executor for the payment their work to get things done, or they can even itemize hourly if they'd like, and so we can see what work they put in, especially a vehicle or an annuity or some difficult asset to sell. Savings bonds might be a little more difficult and might take more time. Any other questions on assets? I guess I mentioned litigation assets. The two types of litigation we see most often are either a wrongful death or, I guess I've reported here, medical negligence cases. Those types of litigation assets, a lot of times there'll be a different type of claim other than estate recovery by I call the casualty lien recovery program, where if somebody gets in a car accident and there's a liable party and the Medicaid recipient sues the liable party, those funds will be subject to repayment of the Medicaid debt before death because there's a tortfeasor that's liable for paying the injured parties and the injured party's medical expenses, and to that extent that will be subject to repayment of the Medicaid debt. If then that person passes away and either the litigation hasn't been settled or the funds are still to some extent remaining with the Medicaid recipient, or if it's a wrongful death action, then those can be subject to estate recovery also through the probate process or otherwise. Wrongful deaths, the way the statute is written, it's not limited to people 55 and over or in long-term care. It just says Chapter 249A. So there might be some wrongful death cases, and we have some, where there's younger people who are in an accident, there's a lot of Medicaid provided to them, there's a wrongful death action, and Medicaid has a right to recover from those if it meets the requirements of Chapter 633.336. I think that touches more on the assets. Does anybody else have any questions on assets? Probate assets, non-probate assets? Oh, I've been talking about probate assets mostly. There's the non-probate assets, and those are really the more contentious assets because there's a beneficiary designation. For example, we often get questions about life insurance. Life insurance is different than practically all other assets. I guess another would be pensions are often not subject to recovery because the Medicaid recipient did not have an interest in it at the moment before death. Life insurance that makes it through through the Medicaid process usually has no cash value or a very low cash value, so there isn't an interest in it before death. And Iowa Code 633.5 says life insurance is not part of the estate. So the only times when life insurance is subject to recovery is, and we've got 4 exceptions that I have found over the years, is if it's actually the beneficiary is the estate. Of course, it's payable to the estate then. If the beneficiary is predeceased, because then it would then be payable to the estate. If the life insurance is assigned to the funeral home, then it's very similar to a burial trust fund, and any excess funds after the payment of the funeral and burial are subject to recovery. Or if the life insurance is often not known about when they apply for Medicaid, So there is a whole life policy or some other policy that's out there and it's not reported. If it's not reported and should have been, it technically would be an overpayment recovery because they weren't eligible at the time of they were on Medicaid. So it then would be subject to recovery because it would have made them ineligible earlier. So that situation doesn't happen very often, but is one we're watching to see if there's life insurance policies that aren't reported. Sometimes we find those through the Great Iowa Treasure Hunt, which is, we have a program with the Great Iowa Treasure Hunt that we do collect assets from that program also. Some other non-probate assets, well, I mentioned life insurance. Annuities, people will say annuities are like life insurance, and they are not like life insurance. Annuities are an investment, just like a bank account, just like a pay-on-death account. They're an investment, and they are subject to recovery because the beneficiaries have no interest in it until the time of death. And prior to death, the deceased Medicaid recipient had an interest in the fund, so they are subject to recovery. Of course, there's life estates, and those are subject to recovery to the extent the deceased person had an interest in it, and we usually determine that by using a table that's found in we use the Iowa Revenue Table. The Department of Human Services uses a different table for valuing life estates before death. Some of these cases, and on the third page of the outline, the longer outline, there are several cases that deal with, one of them deals with life estates, which is a state of loghead. There's a couple of them that deal with jointly held property, and we mentioned jointly held property in the context of bank accounts. The same thing is true with real estate. To the extent the deceased person had an interest in that property at the moment before death, it will be subject to recovery. And there's two of those jointly held property cases, which is Kirk and Sarovi. Another big issue that's come up several times is trusts that have been the deceased person had an interest in at the moment before death. There's 3 or 4 of those on the list of cases. 4 of them all deal with a particular type of trust, which was at one time called a discretionary support trust, is now called a discretionary trust with standards by the courts. And those provide for discretion in the trustee, but also for example, care and maintenance or benefits and support, or some language that gives an interest to the Medicaid recipient subject to some discretion in the trustee. Those cases for your review on the third page of the outline are Barkema and GIST, G-I-S-T, and also down at the bottom in a Court of Appeals case, Kinzel and Roth. And all those cases involve the same type of trust. A 5th trust case arose this year, at least the Supreme Court opinion was this year, called Estate of Melby. In Melby, there was one provision in the trust that said that at the time of death they wanted their indebtedness paid from the trust. And the question, there were several questions raised, and there were a few addressed by the Supreme Court, but the primary question in the case seemed to be, does that right to have your indebtedness paid include the medical assistance debt that comes due at the time of death? And the Supreme Court held, yes, it does, that the phrase, pay my indebtedness or pay my legal debts in a trust would require the trustee to pay the medical assistance debt at the time of death. And that is cited in the outline on page 3 also. That's where a lot of the litigation has been over the years in those expanded probate assets. I've mentioned annuities and trusts and life estates. We do have several annuity cases, but only at the district court. I think we have 6 of them now. They have not been appealed. They have all been successful by the department. And they are based on the same principle as the ones that have reached the Supreme Court on interest in trusts and life estates and jointly held property. There are a few others cases on page 3 for Court of Appeals cases. I won't go through them, but they address several other issues with the state recovery. There's also a page number on that outline that directs you to where those pages are located, those cases are located, and there's a brief description of those cases for your information. That summarizes the asset part of the discussion. If anybody has any other question about assets. Yeah, Ray.
Question on the Medicaid scenario. As you mentioned, that was a situation that seemed permanently a provision in the trust that said that that's what the trust order would be paid. I think that's what the Supreme Court focused on. In the case, as I recall, it was irrevocable trust established more than 5 years prior to that eligibility and so forth. And the grantors retained the right to receive discretionary distributions during life, if I recall correctly.
Mm-hmm.
So the court, in the long opinion, basically came down on relying on the debts clause in the trust document. My question is, what if that had not been in there? Would that have made a difference with regard to the litigating position of Department of Human Services? You have the same scenario, but that clause is not in the trust.
Yeah, and we often see those types of trusts. The Melby Trust was essentially, if I recall correctly, it was more than 5 years before eligibility, which is typical. Often these trusts are over 5 years before eligibility. That's fine. We don't really look at the 5 years. We look at what was the interest of the deceased person at the time of death. So it said generally, and it was a farm, that the mom and dad or husband and wife could have the income off the farm during their lifetime, and then at the time of death, then their debts would be paid and the rest would be distributed to their children. And so your question is, what if it didn't say their debts would be paid? Then it would be like many other trusts that we see that just say they get the income off the farm, and then at death the money's given to the children, and there wouldn't be any recovery without that provision, because it would only say they get the income. Well, there would be recovery just to the extent they still had some income off the farm in their bank account at the time of death, or if they were owed some income off the farm at the time of their death, and it would be subject, but only to the extent there's an interest in the trust. And we focused very, very closely and carefully on what was the interest in the trust according to that will or according to those trusts that were created. So the question was on the Melby case and that particular provision. Did you have a follow-up question?
Would the right to the income be valued like a life estate?
There's often a close relationship between the life estate created through a trust and a life estate created through the real estate. We tend, the analysis has always been that the life estate that's created, we use the tables. If there's a trust that creates some type of life estate interest, we try to analyze more closely what exactly is that interest that they received. We have seen a trust recently that said, I give my son or daughter a life estate in the property. Well, then it would be a life estate. It would be a life estate, but in that case it would not be recoverable under current Iowa law because it's not a retained life estate. We can only recover from retained life estates. So if it's mom and dad giving a life estate to one child, the remainder to the other children, there wouldn't be recovery because it wouldn't be a retained life estate. However, if it was a husband giving a life estate to a wife with the remainder to the children, that would be recoverable because the life estates between spouses are subject to recovery under the definition in the Medicaid chapter on life estates. So,
in the trust context, that surviving spouse has the right to all the income from the trust. That would be valued like a life estate. Is that correct understanding?
I don't believe so. It certainly would be. I've always thought of a life estate. Again, the question was a follow-up on whether the difference between the income off property and a life estate in the property. And we've always interpreted the income as being a monthly payment or income stream, more like an annuity coming off the farm, so much per year, so much per month, whatever. as opposed to a life estate, which entitles the person often living in the house to make subtle changes to the house. They could fix it up, they could improve it, they could depreciate it, which is more likely, but they have more decision-making ability in a life estate than just in income from a trust. So there's a distinction there, and it's really a separate line of cases and a separate analysis, and I don't like to blend them together. I think there's a distinct difference between an interest in a trust and a life estate, and they're really separate provisions in the Iowa Code for each of them. So, going on to the next, probably should touch on expenses and some of the other questions on the list. What expenses have a higher priority? Of course, this is set forth in Iowa Code 633.425. The court costs of administration, funeral and burial expenses, debts owed to the federal and state government. Sometimes that includes cost of administration, could include the sale cost of the house. Of course, it includes attorneys and executor fees. Debts owed to the federal government could be a FHA loan, could be a Medicare subrogation claim or something like that. Don't very often see federal priorities in that statute. The state claims could include county claims, as we talked earlier in the elder law section meeting, from Chapter 252 or other county claims. Medical bills of last illness is number 5. Of course, they're ahead of the Medicaid debt also. They have to be of last illness, which we've got some cases that interpret that be in the last 2 or 3 months before death. Could be longer, but it should be focused more on last illness rather than a nursing home debt that's 3 years old or a medical bill that they just didn't collect earlier. It also has to be a medical or hospital bill of last illness, specifically according to the statute. So it's not a son or daughter in there taking care of the person. It is specifically a medical or hospital bill. Funeral expenses have a priority. They must be reasonable. And we've seen some expenses that are clearly not reasonable, and we do question those. For example, we did see a bronze casket for $22,000 for a Medicaid recipient. We objected to that. We currently have pending a $10,000 burial monument, and we will be raising questions as to that also. So we do have certain categories that come above us, but so that we scrutinize. There are also some that come below us. For example, child support is a lower priority claim. They do have certain ways to attach assets before death, and if they attach it before death and it's not there at the time of death, then it would not be part of the estate and subject to recovery. But if it's still there at the time of death, estate recovery would have a priority over child support, over labor claims, like if the person owned a business, or over general claims like a lower or an older medical bill or a credit card debt or something like that. Any other questions generally about estate recovery? I've covered most of the questions on the list, kind of out of order, but I think I've covered most of them. There is a question, is there interest on medical assistance debts? And yes, there is. It starts 6 months after death, so there's basically about 6 months to wind up the case before interest starts, and we do see a lot of payments, a lot of checks at about 5.5 months to avoid that issue completely. Maybe there won't be any interest because our debt is bigger than the assets anyway, but they just want to get it done and not have to worry about that issue. And it's only about 2.2%. It's the standard statutory judgment rate. So it isn't a large issue, but it does cause more correspondence back and forth as to what exactly is owed rather than paying it within the 6 months. I think I probably should touch on Medicaid trusts a little bit. I know we're going to have another session probably on Medicaid trusts, and Scott and Greg are very, very familiar with those. But as they relate to estate recovery, since they most often conclude at the time of death, and the estate recovery is collecting other assets at the time of death, it makes sense conceptually and reasonably that the estate recovery receives the payments from those Medicaid trusts also. The significant difference between Medicaid trusts, and when I'm talking about those, I mean Miller trusts, which are also known as medical assistance income trusts, and special needs trusts, which have a variety called pooled trusts. The difference between those is that the Department of Human Services is actually the beneficiary under those trusts. So it's not really a claim we file against the trusts. We would just be advising the trustee of the amount of the debt and receiving whatever assets are left. So since April of 2012, our office has also been running the Medicaid trust program that reviews all those trusts coming in and winds up those trusts at death. We've been running the estate recovery program since 1995. It's under contract with a company called Health Management Systems since 1994, and our local office in Iowa has been running the program since 1995. The Medicaid trust program and Medicaid trusts will have a beneficiary. We receive the money back at death. So if there's the biggest difference for estate recovery purposes is that if you've got two bank accounts, $1,000 in the personal needs account, which people can receive when they have a Miller trust, $50 a month, or some of the money they had before they applied for Medicaid. So they've got $1,000 in their personal account, and they've got $500 in their Miller trust account, and they still have some funeral expenses remaining of $1,200. How can they be paid? Well, only the personal account can be used to pay the funeral expenses, because the Miller trust can only be used for medical expenses. So that's a difference in our office when we see a Miller trust. And that would be the same as special needs trusts. Special needs trusts are just a lot larger. Miller trusts, I like to call them medical assistance income trusts because they are only income in those trusts. On the other hand, special needs trusts are for people, and Miller trusts are usually for elderly people in nursing homes. That's how they were originally started. There are some others that are not necessarily in a nursing home, but they typically are for elderly people. Special needs trusts, on the other hand, and pooled trusts are for people 65 years of age and under, or at least they're started at that age most often by statute only in special needs trusts, and there's some exceptions for a pooled trust, so you could start at over 65 years of age. But the people also have to be disabled to get a special needs trust, and then those trusts are only used for the things above and beyond what the disabled, above and beyond what a normal person would need. In other words, what they're tailored to spend the funds for the needs attributed to the disability. And if there's any funds at the time of death, those also are paid through the estate recovery program. We started at exactly 2 o'clock. It is now 2:58. So we have a couple minutes, literally a couple minutes for questions. So I'd like to have a couple just to finish us off here. That is an excellent question. I speak with the Funeral Directors Association every year for about a half an hour only on funeral issues, and that is one that is very important to that group for sure. The question was, what's the difference between a non-guaranteed burial fund and a guaranteed burial fund? A non-guaranteed burial fund is when somebody shows up for the Medicaid office and they've got $8,000 and they're over resources, they can go to the bank, set up a CD, connect it to the funeral, or go to the funeral home and set it up, and there's money there to pay their expenses. It's called non-guaranteed because they don't guarantee the funeral home won't guarantee the services because the cost of the services could increase more than what the CD will pay for interest. So it's just some money set aside. If their funeral costs more at the time of death, somebody's going to have to contribute some more money. If it costs less, there's going to be money that's left over. On the other hand, the guaranteed funeral and burial trust, the funeral home agrees to a set amount for their payment before death at the pre-need time when the person is setting up the trust, usually when they're going on Medicaid. They'll have that same $8,000 or $10,000 or $12,000, and the funeral home will say, okay, it'll be this casket, this vault, these services, and that will cost you exactly this amount. Then the It's basically bought and paid for, and whenever the person dies, I hate to say it doesn't matter, because it does matter to a lot of people, but whenever the person dies, that funeral is already taken care of with the money that was set aside. So that's a guaranteed fund. For the guaranteed funds, those are not subject to recovery if the guaranteed service is provided. They can't take the $8,000, spend $2,000 on a cremation, the family gets the rest. It has to be guaranteed services are provided, and then there's no estate recovery from that. If there's extra money, it's the funeral home's money because they agreed to take that amount to pay their funeral expenses. And for the non-guaranteed burial funds, the funeral directors passed a law in 1996, or promoted a law in 1996, to make certain that there was estate recovery from what's left, so the family did not go in, set aside a bunch of money to get on Medicaid, and then take the money at death and cheat the funeral home out of the expenses that they had set aside or planned to provide. So it protects, both types of burial trusts protect the deceased person, the Medicaid recipient, for getting the services that they requested when they set up the pre-need account. All right. Thank you very much. It's 3 o'clock. We've had an hour here. I appreciate your attention.